Okay, so we'd like to start this afternoon's panel. We'd like to start this afternoon's panel. Thanks for joining us after lunch. So today we're talking about ideology, totalitarianism, and law. We have what promise to be 3 interesting talks. So I'll just start with our first speaker, Benjamin Bukor. He studied law and history and works on as a research assistant on a project on Austrian civil law jurisdiction under the Nazi regime. He's from the University of Vienna, and he will be speaking on civil law and ideology, the transformation of Austrian paternity law? Sorry. Austrian paternity law, 1938-1945. Sorry.
Thank you. Oops, no. Here we go. Thank you for the introduction. My contribution to this year's conference would take a glance at the Austrian legal history in the first half of the 20th century, mainly during the era of National Socialism. For a long time, the research on law under the National Socialist regime was focused on criminal law and public law. Civil law, the field I will be talking about today, was considered to be a legal area untouched by ideology. It was not until the 1970s that researchers in Germany started to review the role of civil law methodology, and civil courts during the time of National Socialism. For various reasons, a critical review on the role of Austria between 1938 and 1945 was not initiated until the 1990s. Therefore, Austrian civil law and civil court jurisdictions have not been subject to a profound examination from this angle so far. This presentation will provide an insight into the transformation of civil law under National Socialism based on a selected area of private law, that being the law on parentage, and in particular, the right to contest the legitimacy of a child. I will show that law on parentage in Austria was not only altered by legislative acts, but also by judge-made law. Moreover, in certain cases, the state tried to influence individual court decisions in other ways. Let us take a closer look at an individual case. This case is taken from the holdings of civil court records at the Viennese Municipal and Provincial Archives. These court records are reviewed as part of the project of the University of Vienna and the Austrian Science Fund that I'm working on at the moment. The plaintiff was born on the 20th of February 1898. According to the National Socialist racial classification, both her legal parents were considered Jewish. Therefore, the plaintiff filed an appeal at the Viennese Court of Civil Affairs in 1940 to challenge the paternity of her father. The court directed to perform a so-called Erb- und rassekundliche Untersuchung, which can be described as a biological examination to determine her biological descent. This biological examination typically consisted of a blood test and the measurement and comparison of different morphological characteristics. Under National Socialism, this kind of biological examinations became mandatory in paternity suits that contested the racial status of the appellant. In this case, due to the lack of pictures of the alleged biological father, the examination could not give a clear result. The child's parents, as well as several other witnesses, testified that the mother had had an extramarital affair with an Aryan student. Some witnesses even emphasized that the family held up a Catholic spirit, but none of the evidentiary material impressed the court. The judge even claimed that Jews would often try to hide in the Wirtsvolk, as it's called in German, the host nation. Therefore, the judge argued they would often convert to Catholicism or even seek the company of German nationalistic circles. The appeal was rejected in 1942, and Gestapo records reveal that the appellant was deported to Theresienstadt 2 months later and murdered in Auschwitz in 1944. In the light of such a decision by a civil court, several questions arise concerning the role of civil law jurisdiction. First of all, how was paternity law changed or modified by National Socialism? Secondly, which functions did civil courts assume within the system of racial classification and discrimination? And which factors influenced the judge's scope of action and the way he considered evidence? Let us take a look at how the Austrian civil law codification regulated constructing and contesting the legitimacy of a child. The establishment of legal parenthood was not directly based on biological lineage, but on assumptions and social factors. For example, the husband, oh wait, it's too early. The husband of the child's mother was assumed to be the child's father if the child was conceived or born in wedlock. Such a regulation is not extraordinary because the principle pater est quem nuptia demonstrant was and is common in most of the European civil law system. In contrast to many other modern regulations, or to many modern regulations in general, the possibility to contest matrimonial paternity was subject to serious restrictions. In paragraph 158 of the Austrian Civil Code, only the mother's husband was given the possibility to contest his paternity. The time limit given to the mother's husband was very short. He had to file a paternity suit within 3 months, starting at the moment that he first learned about the birth. It was not of relevance whether or not the father learned about information indicating that he was not the child's father. The child itself could only contest the paternity if the husband had died before the time limit expired. Other parties, especially the mother, could not contest the paternity at all. There are different reasons for this regulation. On the one hand, the legislator considered practical reasons. For example, at the time this regulation was introduced, scientific evidence to prove or disprove biological paternity did not exist. On the other hand, the regulation was also influenced by the traditional image of family. First of all, marriage was considered the preferred basis for a family, and it was assumed that growing up in a traditional family structure would benefit the child and his future development the most. Moreover, the legislator aimed to protect the family peace and therefore to restrain people from litigating about the biological parentage of a child born in wedlock. Another argument lies in the patriarchal family system that was supported in the Austrian family law. A legal textbook of the 1920s suggested that a child born in wedlock can be in the husband's interest also, even if he wasn't a biological father. Therefore, the decision on whether to contest paternity or not was left to the husband only. When the National Socialists seized power, the significance of blood relations was fundamentally changed. The ideas of racial hygiene and genetic health played a central role in the National Socialist ideology. These concepts condemned so-called racial crossing and tend to prevent people of different race from having children together. People who were qualified as having genetic disorders should also be prevented from having children. On this account, blood relation became a central element in several legislative acts, for example, the Nuremberg Laws. Soon after the annexation of Austria to the German Reich, these laws were also implemented in Austria. Responsible for the racial classification of German citizens was the Reichssippenamt, and it's translated in the literature, in English literature, as Reich Kinship Office. And since 1936, the ancestral certificates of the Reich Kinship Office received official status and were referred to as Abstammungsbescheid. An administrative appeal against such a decision could be filed at the Ministry of the Interior. The ancestral decisions of the Reich Kinship Office were mostly based on official documents such as birth and marriage registers. In cases of doubt, for example, if no official documents existed, the Reich Kinship Office appointed anthropologists to conduct a biological examination. Alternatively, the entries in these registers could be changed by filing a paternity suit at a civil court. Under these circumstances, civil courts became indirectly responsible for the racial classification of individual persons. Against this background, parentage gained a new meaning, and the challenge of paternity has taken on a completely different significance. While the Austrian law on parentage up until then had focused on the social status of the child and the well-being of the child, nationalist socialist thinking put the biological truth in the first place. This triggered demands to adapt and interpret the existing tool of civil law in a way consistent with the racial policy of the Third Reich. While the paternity law of the German civil law codification was modified in 1938, the legal situation in Austria did not change until 1943. In 1943, the Verordnung über die Angleichung familienrechtlicher Vorschriften was implemented in Austria. This law introduced the regulations of the German part of the nationalist state into the Austrian civil code. I will not go into detail about the regulations that were introduced, but I want to give a general outline. First of all, public institutions were given a lot more possibilities to influence the court procedure. Not only the judge, but also the public prosecutor could intervene on behalf of the child or on behalf of the state if the matter was of public interest. Such an interest was assumed if the racial classification was indirectly at the stake. Another crucial change affected the time limit. The time limit now started as soon as the husband learned about information that made him doubt that he was the child's father. Even if the time limit came to an end, the new law provided a possibility for the federal prosecutor to file a paternity suit in the interest of the child or in the interest of the Volksgemeinschaft, of the national community. If we take a look at our case again, we see that it was filed in 1940. At that time, an appeal like this would not have been possible under the regulations of the Austrian Civil Code, because the time limit would have passed 3 months after the father was informed about the birth of his child, which was in 1898. So how could this suit be possible? As the paternity law was not changed until 1943, the Reich Supreme Court introduced in 1939 an action the Austrian Civil Code did not provide. The Reich Supreme Court introduced a possibility to contest their own bloodline descent. This suit gave the appellant the possibility to challenge a certain aspect of paternity, even after the expiry of this 3 months time limit. At first, it was only allowed for children with Jewish descent. Later, the Reich Supreme Court decided that every child was allowed to file such a claim. This suit was called Abstammungsklage, or Klage zur Feststellung der blutmäßigen Abstammung, which can be translated as declaratory action to determine a person's blood descent. A successful claim did not affect the legal obligations between the legal father and the child. So child support, inheritance, all these legal relationships were not touched by this suit. The blood descent only affected the racial status. In our case, such a suit was filed. Which factors influenced the court's decision, the individual court decisions? First of all, the state made legal changes that took the court procedure and the procedure of taking evidence from the parties into the hands of the judge. Moreover, the state prosecutor was able to participate as party in the procedure. For example, he could request the taking of evidence and give his advice and opinion to the judge. The Reich Ministry of Justice tried to regulate the ways judges considered evidence. In 1941, a directive was passed which instructed judges not to rely only on the testimony of witnesses. Especially the mother's testimony was not considered reliable. Therefore, judges were requested to perform a biological examination if possible. But, as in many cases, the legal and alleged parents had died already, or there were no pictures available, the biological examinations often did not bring any definite results. And also the method used in these examinations were not really reliable, so it was questionable if it was really scientific, these methods. Therefore, in many cases, or in most of the cases, it was up to the judge to decide how to use these results. Besides, and we can also see in our case, the biological examination did not bring any definite result. Besides legislation and ministerial orders, the analysis of the court records has also brought some other factors to light that could have influenced the judge's decision. State and national socialist institutions such as the Zentralstelle für jüdische Auswanderung, the organization responsible for the deportation of Jews from Vienna, as well as the Gestapo and the Reich Kinship Office, tried to influence the court procedures. Many court records contain letters from these institutions, and although their statements were mostly directed against the plaintiff's claim, the outcome of the respective lawsuit does not show a direct influence on the decision. So there's no evidence of a legal or factual obligation of judges to follow these opinions. Another probably more efficient tool of the National Socialist Party was the staffing policy at the court, which obviously aimed to install judges who were loyal to the ideology for challenges of Jewish descent. The analysis of the court records of the Viennese Civil Court shows a distinct tendency. In 1938, 12 such suits were decided by 11 different judges. In 1939, 21 decisions were delivered by 14 different judges. In 1940, 72 decisions were made by 21 judges, but a fundamental change appeared in 1941. Two-thirds of 72 decisions were decided by only 2 judges, Judge Wintersberger and Judge Hilscher, and it is striking that the percentage of refusal by these 2 judges was 85%, whereas the average percentage of refusal by other judges was only 25%. And moreover, these 2 judges are of special interest because their decisions contained a lot of ideological argumentation. What conclusions can we draw from what has been said? First of all, how was paternity law changed by National Socialism? In general, it can be noted that the paternity law was altered on different levels during National Socialism. The changes by the legislator, as well as the judge-made alterations, were caused by the new meaning of blood relations and biological truth, and the importance of biological truth in the National Socialist ideology. Which function did civil courts assume within the system of racial classification and discrimination? Since the annexation to Germany in 1938, the civil courts in Austria played a central role in the racial classification of its citizens. Although the civil courts did not have the competence to change the racial classification directly, civil courts' decisions constituted the basis for ancestral decisions by the Reich Kinship Office. And which factors influenced the judge's scope of action and the way he considered evidence? As the National Socialists did not put too much trust into the civil courts, measures were also taken to influence individual decisions. Nevertheless, the principle of free evaluation of evidence was not restricted, and there are examples that judges decided against the opinion of state or National Socialist institutions just by relying on the evidence. And in the end, every decision was up to the judge and his personal and ideological attitude. Thank you for your attention.